Welcome back to Legacy Protected, navigating estate planning and probate in Southern California. And we are back today with Shanda Beach of the Beach Law Group. Welcome, Shanda.
Thanks, DeDe. Thanks for having me. I'm enjoying my time here. I'm looking forward to talking about more legal issues with you.
Awesome. So I know in our last episode, we sort of concluded with the topic of touching base about AI. And I know the probate world, mainly law in particularly, is very archaic, and estate planning more so than business litigation and trust litigation, actually. But AI is almost becoming an everyday word. Can you kind of describe some of the pros, the cons? Are you using it? What do you like to use about it?
Sure. We do use it. We kind of dipped my big toe in, and there's a lot of ways to use it in the legal practice, as you know. One of the ways it can save time. We use it to, for example, summarize depositions. That used to be a job maybe for a paralegal that would take 3 or 4 hours, depending on the length, and now takes about 3 minutes, saving the client time. And so in that sense, AI is great. You can just use it in a practical sense to organize things within a law practice. However, AI can be very dangerous in the sense that, for the legal practice anyway, because it hallucinates, meaning that it's an algorithm that's coming up with the next word. And I'm no expert on AI, but I do know that, and that has put a few lawyers in deep trouble with the court system. They're, a disciplinary action and sanctions because they have used AI to put together a brief to the court or a motion and cited to something that AI has told them is accurate. It absolutely doesn't even exist. That's the hallucination factor. So it can be a disastrous thing to use in the legal field just because it doesn't reason yet. It may get to the point, right, that it can reason and have judgment. It's not there yet. So it's just kind of a word of caution,
Especially for those do-it-yourselfers, right?
Oh, exactly. It does kind of dovetail into do it yourself. I'm assuming our listeners are using AI to kind of shortcut the time and cost that litigation can have.
I think it adds to the sophistication of a client, right? If they don't have any knowledge in a particular field or just in litigation in general, it can educate and
if it does it correctly, right? If it's correct, right? So, but if it's hallucinating and coming up with cases or propositions that are not accurate or don't exist, then of course everyone's in deep trouble. Not just the attorneys, but the clients as well. The other thing AI doesn't do, if I could just throw that in, is obviously it doesn't use judgment. It doesn't show up in court for you.
It
doesn't pick up.
At least not right now, right?
Not right now. It doesn't pick up the phone when you have a question or a concern. And so it hasn't taken over for lawyers yet. I even used AI and got a wrong answer. And I was trying to check on how many days I had to file a certain document. I knew it was 15 or 30. I couldn't remember which one. So I went into Google. And of course, the first response is from AI. And it said 60 days. And I knew that was wrong, just like you knew the extra form was wrong because of our 20, 30 years of experience. We know what we're doing. And so I looked, and when I double checked the source, it was the appellate court rules. And of course, not to get too deep into it, but the appellate court rules are very different than trial court rules in terms of timing. But I only knew that because I'd practiced so long, and I knew that rule basically. So again, even I came up, with an AI incorrect answer that I had to correct in my own. Yeah, I had to correct on my own. Yes.
Right. You had to go to the code book and verify. Right.
When all else fails, check the law, right?
Check the law. Exactly. Which that kind of goes to the whole do-it-yourself, right? And I know in estate planning, many people think, oh, it's just a will or it's just a trust. I'm going to go online and do it. And my responds to that. And I used to get very upset with people and try and educate them, and I still do. But at the end of the day, you're acting as your own attorney, right? When you do it yourself, whether it's a will or a trust or a contract.
Yes.
And I'm sure you'll be able to give me some examples, but really you're inputting this information to create your own will, create your own trust. And I finally got to the point where I just said, I can talk until I'm blue in the face that you should not go to one of these do it yourself online wills or trusts but what ended up happening is usually when it works, right? And you know what? Absolutely. If it works for you, fantastic. However, when it doesn't work, it actually causes a lot more expense, heartache. That's where we go into probate litigation, trust litigation. I have to say, if I reflect on our matters that are in litigation, and whether that's probate or trust, almost 9 out of 10 times, it's because someone did their trust or will themselves and they forgot to put in a child. They forgot to put in a spouse. In one will, they were doing reciprocal wills, which you can't even do that. They need to be a little bit, changed up, where husband and wife created a trust. Well, it ended up that husband signed wife's will and wife signed husband's will. It again, it was because they did it themselves. And so I'm of the position, of course, you should hire the expert. You should hire the person that knows what they're doing. And with blended families, it can get really ugly. And we were in probate because these two wills were not signed appropriately. And they ended up actually just dying intestate, right? So intestate means you die without a will. So I don't even know how much they paid for this do-it-yourself will, but at the end of the day, it cost them money because now we had two
Well,
people.
and you mentioned, sorry to interrupt there, but you
No,
mentioned at the beginning, you mentioned that sometimes probate, the law of probate and trusts is a little bit archaic. And my recollection is it can be, but it's also very statutory. It's also very specific. You use terms that most people don't like issue and
right. Per sturpies.
People per sturpies and issue things that are just not normal vocabulary, like beneficiary that people understand. Right. And so their intent might not get into their homemade or do it yourself wills because they are not expressing it legally.
Is there any other sort of war stories regarding do it yourself litigants that you have come upon?
I'm trying to think of some off the top of my head. The signature one was so simple, but there are a lot of contracts out there that have been done by small business owners, usually maybe entrepreneurs, small business owners, usually not the bigger corporations because they have legal departments or they've gone through this process so often. But they may end up doing something like defending and indemnifying, so agreeing to defend and indemnify the other party. They don't even know what that means. That can be very costly. That means you're paying the other person's attorney's fees from the get-go if a complaint's filed, not at the end. You may agree to a Wyoming as a jurisdiction, not just for the law that's going to be applied, but for the venue, meaning you might have to go to Wyoming to litigate your case.
Yeah,
exactly.
And you didn't even know because maybe someone didn't read the contract or didn't seek some legal advice as far as what the contract says.
Exactly. I had that happen with a commercial real estate broker fairly recently, within the past 6 months, looking at his contract. Smart guy, very good in his field. I was just kind of a backstop to look at the agreement, and it just had some errors in it. It had some years. He wasn't eligible for certain compensation until a year after he signed, and he thought he would be immediately eligible. I don't think the other side was necessarily trying to do anything nefarious, but legally, we had to change it.